Waverley.
Thank you, Acting Speaker, and I also rise to speak on the Workplace Injury Rehabilitation and Compensation Amendment Arbitration Bill 2021 and get to share my voice along as I think all of my colleagues definitely, and hopefully those on the other side who I don't believe are opposing this bill, which is good news, that just the importance of workplace safety for all workers and also for the employees as well, who usually work in their own business. So this is for everybody. And obviously we're talking about workers, but I obviously thank the Minister for Workplace Safety for her considerable work in this, and the Attorney General, but also our former fantastic Attorney General, who is sitting here as well. Considerable work. I'll give it a go. So, look, workplace safety is fundamental to a safe community, a thriving economy, and fundamental to this government and the Labor Party that I am a proud member of. And the changes in where and how we work continue to create new challenges for us all and for the safety of us at work. And it was only yesterday in the House that I was speaking on the Industrial Relations Bill. I was talking about the gig economy and our delivery drivers who are now employed via devices. And what we see with that is an increasing pressure on those drivers to do more and more work in shorter and shorter time spans. And of course that decreases safety. That pushes those workers to try and earn that little bit more, to get that job done quicker. Now some of those employers, and I'll call them employers because that's effectively what they are, some of those employers take that to levels where if you're not quite quick enough, they throw you off the system. I was very happy, as I said yesterday, to see Hungry Panda actually reinstate 2 workers who were going to take them to some litigation, and I'm glad that that was sorted. But this is thin edge of the wedge stuff, and it's something that I'm definitely keeping my eyes on, and I know that we will continue to work for the benefit of all workers, including those in the gig economy. Now, also in 2019, I was happy to see when our government altered the way that we record workplace fatalities on the road. And in July 1, we will now start to count those workers, our transport workers, who unfortunately perish on our roads as workplace fatalities. I think that's an important step forward to really understand, because the roads are a workplace. And so I congratulate my good friends down at the TWU and John Berger and his team again for their good work doing that. And obviously the Premier and the whole Andrews government for understanding and doing our work to benefit all Victorians at work. But look, injuries at the workplace can have devastating consequences for workers. And in this case, we're talking about the arbitration scheme that we're putting in this bill. And arbitration is obviously a much easier way to process through the justice system when possible. Now, it's not always possible, and there are mechanisms for still taking things further should that be required. And there are limited appeal processes as well, even if you go through the arbitration, if it's a rule of law matter. But this is a good step, because far too often people who have deep pockets can take advantage of our legal system for as long as they want, and good on them, well done. But those whose pockets don't go quite so deep find it very tough to get their justice. Now, the more we can do to level that playing field, I am all for. And this arbitration process that we're talking about today is one way of making sure that that access to justice for people is fair. Now, as a proud member of a Labor government, it would be remiss of me not to go back to our legacy of Labor governments in this state. And obviously, we said goodbye to Premier John Cain only recently. And in 1985, under his leadership, it was a Victorian Labor government who established the TAC, but also WorkCare, obviously the forerunner of WorkSafe as we know it today. So reforming governments all the way back then. And it's important for us to also realise that these changes take time to really gel themselves in the culture of our state. 85, you might start a reform process, but when we're sitting here in, what are we, 36 years later, 46 years later, whatever they do my maths on the fly, 36. So we have a culture in workplaces now where we know that WorkSafe is there. We know if people see things that are unsafe, they are inclined to talk to their unions, their bosses. They are inclined to, if they need to call WorkSafe and notify them of things going wrong. I remember back in 91, I did a summer in a warehouse running cables locally. It was just a summer job and we earned a bit of money. But we had a lot of very large cables in this warehouse, and by the end of the summer I was driving a forklift around. I didn't have a forklift licence. I don't think anyone in the store had a forklift licence. Now I would hope that that sort of thing no longer happens. I hope the statute of limitations has gone out on not having a forklift licence too, by the way, because I've just owned up to that one. But those things used to happen everywhere. You know, you got a job, young person, you go there, the boss, well, they were good bosses, it was a good place to work, but oh yeah, you'll be right, you'll be fine, no worries mate, there you go. You know, we've seen what happens when it's not fine. We've seen what happens when it goes wrong. Now luckily, nothing went wrong then. No one got hurt. But when you do get hurt, I think we all understand that when you set off to work in the morning, you kiss your family goodbye, there is an expectation that everybody should be able to come home. And if something goes wrong in that process, then it is fair and right that there be some form of compensation. And workers' comp has been around for ages. But the problem, if we go back to 85, I was very young, but my memories are that it was just private insurance companies that you were dealing with. And I don't think all insurance companies are evil. I don't think they're all good. I think they're companies. They don't have a soul, they're just companies. They're there for profit, they're there to do their job. And corporate structures just have processes. And like the member for Frankston mentioned before about some of the emails going back and forwards, you get a few guys that get a bit too excited that they've kept their KPIs down for the month. And then people get hurt. And as the member for Frankston also said, if you don't actually know the person at the end that you're talking about, you may not just gel. That they're real people and they've got families and they're out of work. And as others have said, they want to get back to work. So that process, when an insurance company just does what they do and extends it every day, that's making one person, one family, one extended family, one community worse off. So a bill like this enables a process for us to speed that up, to make it more fair. And we have very, very talented mediators and arbitrators in this state. I know I've had conversations with some of those people around the meeting rooms at the Vic Bar, and they are very serious about alternate dispute resolution. It's a really good process and it works a lot of the time and it saves us all. It not only saves time and money for the people who in this case are injured, but it also saves time and money for the other side. It'll save time and money for the insurance companies because you get together and you work it out. So I think we're doing some very important work here and it continues 6, 7, and I think many more years of very important work that the Andrews Labor government is doing. And I commend this bill to the House.